Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
Hello everyone, good morning Europe, good afternoon Asia, and hello maybe to the ones that will check this webinar after when it's recorded. Today we are very thrilled to have and host a nice webinar on a very cool topic, Agri-Food industry. And so without further ado, we'll go quickly to the housekeeping rules. I'll be the moderator of this webinar, Mr. Benoît Tardy. I'm the IP business advisor for the Southeast Asia IP SME Helpdesk. Here you can see the house rules keepings. I think that everyone knows after several years of virtual conferences that what are the rules, but quickly try to keep your microphone muted. If you have any questions, we will prefer you to use the Q&A feature, the Q&A box, and we'll answer all the questions at the end of the webinar during the Q&A part. If you have any issues, feel free to let us know. Today we'll have several speakers, two main presentations. One from Mrs. Sara Piva from the CPVO, the Community Plant Variety Office, and one from César Elvira Fernández, the IP expert of the Latin America IP SME Helpdesk, but he will talk on behalf of the International Helpdesk. And then we'll have a panel discussion involving several speakers. Here you will see expert from Africa, represent Africa, expert representing India, an expert representing Latin America, and of course myself. Well, quite a big schedule ahead. So, but just before diving into the topic, maybe quick reminder of the services and what we are offering at the International IP SME Helpdesk. So we have the core services. You already saw a bit in the video, but we have the uncried helpline. We also organize very regularly webinars and trainings, workshop, on-site and virtual. We have a lot of guides and fact sheets. Each help desk has its own publications, but we also have some common publications. We will highlight two at the very end of this webinar. And of course, if you want to be updated on all the news, the events, the new publications, you can follow us on social media and the newsletter. So now I think it's almost the time to kick off. Just before, we have what we call an impact assessment. It's kind of a quiz, and I will give you 20 to 30 seconds to think and reply to this question. If you don't know, it's okay. If you already know, well, it means that you already have some kind of knowledge on IP and the topic of today. So the question is, unlike other IP rights, plant variety protection is granted without any registration process. All new varieties will be automatically protected. It's a single question, single choice answer. So either true or false. So you now have 20 seconds still to reply. And maybe by the end of this webinar, you will have the right answer. Okay, I think we can close the poll. So this was the fun part, just to begin, to test a bit your knowledge. So most of the people answered false. We'll see later on what was the right answer, and maybe some comments from our speakers. Now, without any further ado, we will welcome our dear colleague, César. César, if you want to already begin to share your presentation, and César will kind of do over screening of all the IP rights, why IP is important, how to benefit from IP and IP rights with relation to the agri-food sector. César, the floor is yours.
Thank you, Benoît. I guess you can all see my screen, right?
And hear you perfectly. Awesome.
Perfect. So we're going to dive into the two big questions every newcomer of the agri-food sector should be asking, as you mentioned. Why is IP important, and how to benefit from intellectual property? Now, to the first question, why is IP so important? First and foremost, because IP is everywhere, covering every stage from production, processing to packing and distribution. And it's no secret that any company is using someone else's IP or it's generating it. And if we add it to the fact that intellectual property provides a positive impact on their competitiveness and that the consumers grow in standards in aspects such as food safety, geographical origin, manufacturing processes, well, they all have laid the ground for a new approach to the sector where now differentiation through brands or processes is as important as it is in certain luxury sectors, particularly in the subsector of food, I guess. Then you got your answer, okay? But there are more advantages. And here's where we break down how you can benefit from intellectual property. I take for granted that you all know what intellectual property provides an exclusive right. We all saw that in the video before, but maybe you don't know that if you currently protect your intangible assets through intellectual property rights, you may also be able to create a new revenue from flow by licensing them, for example, or to attract more potential investors or financial institutions, to increase the company's competitiveness on the market, or to improve future profitability, and of course, to apply for public loans or grants, among others. Now, each type of intellectual property right is more closely connected to certain products or services or business models. Therefore, SMEs whose strategy is to differentiate from competitors should develop a strong trademark portfolio, for example, while innovators investing in improving their products and processes might be more interested in applying for a patent. What would producers associations be highly recommended to think about? Geographical indications and collective trademarks, of course, because they are perfect to build on the reputation of the characteristics of their products. And in any case, you must know them all, okay? And consider all IP rights to avoid infringing someone else's rights and identify potential business opportunities. So let's check the most relevant ones to the agri-food sectors and their main features. Now let's start with trademarks. In short, they protect signs indicating the entrepreneurial origin of products and services. They might be useful to differentiate products, even to those that have traditionally been commercialized as basic commodities like coffee or vegetables, or of course, cotton. And they are really good to segment markets too. Well, in fact, where the market is highly saturated, a strong branding strategy is a must. Just think about energy drinks like Monster or Rockstar. Coca-Cola and PepsiCo just follow the steps of Red Bull and have developed proactive trademark protection policies combined with really aggressive marketing campaigns. Registration is really simple. You just must figure out if it's locally available, as they are territorial rights. Anyway, please have an international mentality. Please, this is really important. Also, it would be advisable you to look for the meaning of the warning in the markets of interest and conduct a prior trademark search to ensure not only its availability in every relevant territory, of course, but to be sure that you are not applying for a trademark which is offensive or genetic or already registered. What is the initial duration of protection of a trademark, you may be wondering? Well, generally speaking, it's 10 years, counted from the filing date or the granting date, but they can be renewed indefinitely for 10 years period upon payment of the corresponding fees. So it could even last forever if you do your homework. And what happens if you find that your company or product name has been registered as a trademark already? Well, you can sign a coexisting agreement, but please note that this is not available in all countries, or have different names and a common logo. This is something that Unilever did to enter in central countries. What they did is they acquire local brands such as Frigo, Algida, Gibon, Langnese, or Hollanda, and combine them with its heart-shaped logo into a joint trademark. This allowed Unilever to maintain all the positive associations with the pre-existing trademarks, while including all of them under its well-known trademark umbrella. And of course, it prevented them from picking a universal trademark that could meet all the registration requirements. You see, IP is for smart people. This all applies to all types of trademarks, but in this sector, collective trademarks are particularly interesting, namely in two cases: as a substitute for geographical indications and as a warranty of certain characteristics of products coming from different companies. And you can also have certification trademarks, by the way. They are a suitable way of including certain positive characteristics in your products. I'm thinking of eco-friendly, sustainable, pesticide-free, fair trade origin. Well, they all tend to be highly appreciated by consumers, and they could be registered as certification trademarks. Now, then you have also patents and utility models, which protect new and inventive solutions to technical problems. In other words, inventions, like the technology is used for crop development under extreme, more efficient or cheaper conditions, or in packaging and preservations like Tetra Pak, registered trademark, or Ice Wave's deep freezing process. One of my favorites is Floret's vacuum pack technology called New Clean, that keeps the freshness of food much longer, unlike salads, of course. And back to ice creams, remember Calippo? Well, its cardboard folding packaging was protected by the utility model. So how can you benefit from this either 10 or 20 years protection period, depending whether it's a utility model or a patent? Well, you have to meet three simple requirements. First, novelty, meaning that it is not included in the state of the art, meaning everything that has been made available to the public in any part of the world by written or oral description, by user marketing, or any other means, okay, prior to the filing date or the patent application or the priority date. Second step would be inventive step, meaning it's not obvious for an expert with average skills in the technical field concerned, which this is not applicable to utility models, by the way. And finally, we got the third requirement, which is industrial applicability, meaning when it is subject matter may be produced or used in any type of industry, including services. So your inventions must be worldwide new, but it does not mean that a single patent application protects you worldwide. On the contrary, you must register in every territory where protection is sought. Otherwise, anyone else could exploit your technology without you being able to do anything about it. Now, as my mom says, sometimes the best way to keep valuable information protected is no registration, but confidentiality. So if you have some business information that provides a competitive advantage because no one else knows about it, like a receipt or the list of suppliers or marketing plans, then trade secrets are for you. This requires the adoption of reasonable protection measures like non-disclosure agreement or access to the information restricted to a small number of people or technology protection measures, but it can last forever if it stays secret. We can also have industrial designs, which are real important because when an invention does not have a unique functional feature and or does have an aesthetical one, I mean the shape, the color, lines, or dispositions of the product, then it can be protected by an industrial design, and the packaging would be a good example. Now, I know that the life cycle of certain aspects of products can be too short because either you change them constantly for whatever reason. And I know it's tempting not to register it. However, contrary to Europe, where we have a 3-year protection period for designs, in the rest of the countries, unregistered design is not available. So if you're going abroad, either you register or you lose your exclusivity. For how much would you be protected if you register? Well, it depends a lot on the country. It goes from 5 to 25 years, but they are not extendable. Requirements for it, new, it must be new, again, worldwide and industrially applicable. And then you may be wondering, why has no one released a Coca-Cola style crystal bottle? I think it's really classic and should have been already in the public domain. Well, that's because they registered that shape as a 3D trademark, just like Toblerone. That's different, right? And if you want to know more about how they do that, just ask Agri in the Q&A session. And finally, we got the IP right that protects catalogs, multimedia contents like video, pictures, instructions, drawings, or even the company's mascot. So you can either grant some licenses and make money out of it, or get a license, for example, for the most popular copyright protected cartoons like Paw Patrol for your zeros, and then you can make money. Furthermore, we have software for this because computer programs used in the collection of packaging machinery or even your company's mobile app could be protected via copyright. And the duration of protection may last 50 years from the creation date to 100 from the author's death, depending on the country, for which you do not must register. Protection is granted upon creation and extended to almost any country of the world thanks to the Berne Convention. But we really recommend you to do it. It will help a lot in case of infringement. And finally, as to the start of today's show, plant varieties, we'll know about it thanks to our colleague from the Community Plant Variety Office. Benoît, back to you.
Wow, it was like a super quick overview, but I know we don't have that much time. I guess a lot of information, and yes, IP is everywhere. IP is here today, and we will see all particularities later on with the IP experts from the different regions of the world. Maybe we'll have also time to share about Latin America. But first and foremost, now I would like to welcome our speaker, Mrs. Sara Piva from the CPVO. Maybe she could share a bit about CPVO because I'm not sure everyone here in this webinar knows the activities and services, the scope of duty. And well, we're very happy to have you on board, Mrs. Sara Piva. Please, The floor
Thank you very much,
yours.
Benoît. Thank you very much for the floor, Benoît, and welcome to all of you to this webinar. I will share my screen with a short presentation of the activities of the CPVO. So I hope you can see my screen. Apparently, no.
Not yet.
Just a second. Again, it worked perfectly before.
So Sara is a legal officer of the agency, the EU agency, the CPVO. And now we can see the screen coming. So up to you.
Can you see it full screen?
Not yet.
Okay. Apologies for that. I hope you can see it now.
We can see the slides, but not yet in full screen.
I don't know why it goes like that. Is it now in full screen?
Yes.
Okay, great. Apologies. The community, the CPVO is the Community Plant Variety Office, which is in charge of the system of the plant variety protection system of the European Union. So the subject matter of this short presentation will be innovation in the field of plant breeding, the creation of new plants, and why the creation of new plants and the protection of the IP right over new plants and new varieties of plant is important for the benefit of the society at large. So what can we do? What can new plants do for us? Well, the breeding sector contributes to the development of innovative and sustainable solutions that help us to fight the issues and the challenges of climate changing. We can have new plants that are better resistant to new diseases and reduce in that way the use of chemicals, reduce the water use. From a recent study of the impact, the socioeconomic impact of the community plant variety rights system, we discovered that with the protected varieties in the EU have reduced the use of water in agriculture by the amount of water that you can find in the Lake of Constance. So we're talking about 14 billion cubic meters of water, of reduced use of water. So, but what is plant breeding? Well, plant breeding is nothing new. It exists since ever human produced plants, food, and it goes from the classical selection and multiplication technologies and until the very modern DNA and gene editing in plants. And they develop since ever. Farmers started breeding varieties for increasing their yield and to have better varieties for their purposes. And now we have scientific breeding, which is a dedicated type of research that originates from basic research, as always, but then you have the breeding part, which is developed by either the public or the private sector. And of course, plant breeding and plant variety protection contribute, as we were saying, to the achievement of the UN Sustainable Development Goals. Why? Because they increase the possibility of farmers to use better varieties and be able to use less resources. The protection with an IP right, as was mentioned before, gives you the possibility for plant breeders to license their rights and to gain revenues. But not only the breeder benefits from the protection of IP, also the farmer, because if you have a better variety and you can make further income on that variety, irrespective of the classical income that you may have with a non-protected variety. So it contributes also to the green agenda of the European Union. This year, more than ever, since last year, we have the Green Deal and the Farm to Fork strategy. And we are talking about innovative breeding techniques. Currently, there is a discussion ongoing at European level on new breeding techniques. And again, as I was mentioning, the contribution of plant breeding and of plant variety protection to the objective of reaching a more sustainable agricultural industry is challenging, you know, and plant breeding plays a fundamental role in this. So this is not only for increased income, increased yield, and contribution to challenges posed by climate change, but we're talking about preserving biodiversity and food security, which is the most important thing, because we don't have to forget the plant breeding and plants are part of our food. We are talking about the food that we have on our tables. And food security is increased if you have protected seeds and protected variety that increase also, for instance, the security of the seed and therefore of the food. Why? How to support innovation? As we were mentioning before, IP is fundamental, and IP right is fundamental to protect innovation. Why? Because if we don't protect our new products, our new plants, everyone can use them without remunerating the work behind the development of a plant variety. The breeding of the plant of a new plant variety can take up to 15 years of research. So if you don't protect it with an IP, once the product is on the market, the product is freely replicable. So it can be reproduced, it can be commercialized without any control from the original breeder. So if you protect it, you have a return on your investment. So without protecting with an IP right, you will not have a return on the investment that you made on the research of 15 years, up to 15 years. Of course, with new breeding techniques, you can shorten the period of developing a new variety, but that doesn't mean that they're not expensive. So it's not only about a matter of time, but it's also a matter of how much you can invest in innovation. So now I've been talking about plant varieties and new plant varieties, but what is a variety? A variety is defined in our basic regulation, which is Regulation 2194, and it is a plant grouping within a single botanical taxon of the lowest known rank. So it's a bit of a technical definition, but it's the smallest grouping that you can have in the kingdom. So for example, this is a pyramid of how the plant kingdom works. So we go from kingdom, clade, order, family, and then we arrive to the plant variety. One of the most famous apple varieties, our beloved Granny Smith. So the Granny Smith is a variety of apples. Now, you may ask yourself, why should I protect with an IP right a new plant variety when in some crops, for example, this does not apply to ornamental crops, but for the other crops, yes, I have to register it. In the EU, I need a seed marketing authorization to commercialize my varieties of plants. Well, this is true, but this does not protect you. You can market your variety, but once the variety is on the market, the others, the person that buys it, can do whatever they want if it's not protected by an IP right. So with the IP protection, you have the control over your variety. You can license it. You make the conditions. It is up to you. What do you want to do with your variety? To whom you want to license it? For how much you want to license it? So not all varieties that are on the market are protected through an IP right. But of course, the suggestion is to go for IP protection to protect your investment. So in the EU, as I was mentioning, we have a basic regulation, which is the regulation that covers the community plant variety rights, but it is based on the 1991 Act of the UPOV Convention, which is the International Convention on the Protection of New Varieties of Plants. In the EU, the protection has a uniform effect, so you have a unitary title. You apply with the CPVO for a community plant variety right, and you have one title valid in all 27 member states. We protect all genera and species, and the duration of protection goes from 25 to 30 years. 30 years is for trees, vines, potatoes, and recently we extended protection for flower bulbs, woody small fruits, and asparagus, and woody ornamentals. So as I was mentioning, you can have one title valid in all 27 member states, or you can have one or several national titles. What you cannot have is double protection. So if you have a previous national right, while you have a European title, you cannot enforce your national right while the European one is in force. So you can have them, but it's not enforceable. Then what is the advantage of applying and registering within the Community Plant Variety Office? Well, as I was mentioning, instead of going through several national procedures, you will have one procedure only, and your costs will be reduced because the maintenance of the right, the management of the rights cost, for instance, if you have a proceeding before the office, it is only before our office. You have less number of employees, well, for us, involved in prosecution activities, and for you as well, because they have to follow just one title instead of potentially 27. And we ensure legal certainty because we have a history of decisions of the office and, of course, case law that is applicable. Now, the CPVO is an agency that was founded and operational since 1995. We are based in Angers, and our mission statement, as you can see, is to deliver and promote an efficient intellectual property rights system that supports the creation of new plant varieties for the benefit of society. Now, the requirements for protection, we have novelty requirement, which is a commercial novelty, distinctness, uniformity, stability, and you need to give a denomination to your variety. Now, distinctness, it means that your variety needs to be distinct from anything existing in the common knowledge. The uniformity requirement means that your variety needs to be uniform in its expression and in the expression of its characteristics, and stability means that it has to be uniform over the years. So over different cycle of production. Then, as I was mentioning, variety denomination, this is really important to know that the variety denomination, it's the generic designation of your variety. Contrary to what a trademark is, anyone, when using a plant variety, needs to use the variety denomination. So even when the protection, the IP protection expires, the variety denomination stays, and you're obliged to use the variety denomination of the plant. The application process, we receive a CPVO, the application for plant variety rights. We perform a formal and a substantial check within the CPVO on your application. So formal requirements of the form that you submit to us. But then, of course, we're talking about living material. We're not talking about a product. Yes, it is a product, but for instance, it lives. How can we determine if this variety is DUS, as it said? DUS examination means distinctness, uniformity, and stability. We do not perform the test, the technical examination directly in the CPVO. We have 23 at the moment examination offices in the European Union that perform the technical examination on our behalf. So what they do is that when we receive the application, then we ask for the plant material of your new variety that you submitted to us, and we one single examination office based on the crop that you apply for performs the growing cycles. It can be 1 or 2, depending on the crop, depending on the type, of course. They perform the growing cycle, they assess the DOS requirements, and they send a final report to us for the grant or the refusal of the right. What is the scope of a community plan variety right? You have a material scope over variety constituents and on harvested material and an optional extension over products obtained directly from the material of the protected variety. So what does it mean? That when you want to perform one of the acts that you see in the screen, so production, conditioning, offering for sale, you need the authorization of the right holder. The right holder can be the breeder or the assignee. So whenever you have a new variety protected with a CPVR, you need the authorization of the holder to perform all these acts. And on the contrary, the holder can license these rights to whoever he wants. Now, within the scope of the right, we also have exemption to the right. What is the agricultural exemption? Only for certain crops, farmers are authorized to use for propagating purposes in their own field the product of the harvest. So in essence, they can save some material from the sowing, from the harvest, and then reuse this product in their own field. What is the benefit of this exemption? This applies only to certain limited crops within the fodder, cereals, potatoes, oil and fiber plants. What is the advantage? The advantage is that over the saved seeds, the farmer shall pay an equitable remuneration, which is sensibly lower, accounting around 50% of a normal license fee. Then we have what is called the breeder's exemption, which is a huge difference with the patent system, for instance. So when you have a new variety of plant, not to block innovation, not to block research, a breeder can always use the material of a protected variety to develop his own new variety. So there is no blockage in the research chain, let's say. So even if a variety is protected, it can be used for research purposes, and you can develop your own variety from the protected variety without requiring the authorization of the original breeder or the right holder. This applies to any kind of variety. So this is access to the genetic resources and improvement of the existing variety and sources that we have. This is an opportunity to share the benefit of the breeding activities. Now, once you have your right, how can you enforce it? Well, the Community Plan Variety Office does not it does not work as a court for enforcement. So right holders shall enforce their rights in front of national courts. So the applicable national procedural law, criminal or civil, it depends, of course, on the national, on the state or on the country where you want to protect your rights. So there is an exclusive competence of the national courts to hear infringement cases. We have, as a European Union, the obligation under Article 30 of the UPOV 91 Act to provide for appropriate remedies. So, but breeders are responsible for enforcing their rights. We have no role in that. The only role we have is to support national authorities or any other entity involved in the infringement cases to provide information, give files, provide samples, and cooperate with authorities for these purposes. As I was here, you can say how breeders should address the risks. Well, it's difficult. Why it's difficult to detect infringement? Because nature is a perfect copy machine. It is easy to reproduce a plant, and the counterfeit blend looks exactly the same as the original one. So you have several ways of trying to protect your IP assets. Cooperation with the relevant authorities is of fundamental importance. Training of customs and police authorities, they play a pivotal role in this, in recognizing counterfeit. Labeling is important to identify your variety, the denomination, but not only plant variety rights can be combined with other rights. Your plant varieties can be commercialized under an umbrella trademark or a sign that can help to trace and to track your plant variety on the market. So this was it for me. It was a brief introduction. I hope I was clear. If there is any question, I am available.
Brief, but very clear, Sara. Thank you very much. I just shared the official website, the link to the CPVO. And yes, of course, for all the audience, you should be clear in mind that whenever you're thinking about plant variety protection, especially in EU, you have to check the CPVO website, a lot of information available. You are also available for giving advice today or also by email, I guess.
Yes, okay. Of course you can. I can give you my email in the chat, so you can reach out if you have any doubt or question. We have several webinars again conducted with you and with the European IP Helpdesk, so we are available for any kind of information.
Thank you again for joining us today. Now we saw the EU background. We also had many information shared at the beginning by our colleague César. But the most interesting part here is that, of course, it's completely different or a bit different when you go outside of the European Union. And we have today the privilege to have gathered several IP experts from different regions. We have Matias from China, César that we already saw at the beginning for Latin America, our friend Girish today for India, and also colleagues from the Africa Helpdesk that will be able to reply to any answers during the Q&A part. It's a very unique opportunity to have almost everyone here together to speak about agri-food sector and plant varieties. We see that the new plant varieties are continuously being developed to meet global food demand, like more nutritious crops, new varieties capable of higher yields, early maturing, resistance also to pest disease. There's also the environmental issues with the water shortage. Super interesting topic. And we were mentioning, Sara was mentioning that it's basically our food, what we are eating. So we saw that IP was super connected with intellectual property and plant variety, agri-food sector. Everything is interconnected. And I think it's time to approach all the specific particularities we can see when you go outside of the EU. When you check the plant variety protection system, it might be surprising for you, you will see. First of all, I would like to ask maybe Matias, the IP expert from China. Hello, Matias.
Hi.
Does the Chinese legislation currently have a system, specific system to protect plant varieties?
Yes, we had in China one system. We have the seed law that will allow individuals and companies to register plant varieties. Currently, there are two different institutions that are in charge of running those registrations. We have on one side the Ministry of Agriculture, and on the other side the Ministry of the State Forestry Administration. The difference applying with one or the other one would be depending on if we are registering a plant for agricultural purposes or not.
Do you have a bit more information about the costs or the time frame for registration?
Yes, the costs for registering, we have to talk about two different costs. For an application fee, it's 1,000 renminbi, which translates into 130 euros. And for the examination fee, it's 2,500 renminbi, which translates into 325, 30 euros. Regarding the time frame, well, we say that on average, it will take around a year. If we check the law, we can see that once you pay the application fee, the application should be run within a period of 1 month, and then the offices have 6 months to analyze the plant variety once you pay the examination fee. However, with delays or no delays, it takes around on average 1 year.
1 year, okay. Is it the same? Well, today we have Girish speaking on behalf of India, but also Africa. I guess Girish may share a few words regarding the registration system in Africa. Can you highlight like the most relevant aspects about plant varieties in the continent? I heard that there were 2 different systems, RIPO, OIP. If you have anything to share, yes.
Yes, exactly, Benoît. You were absolutely right. There are 2 different systems. And when we consider Africa, it's a huge continent with numerous countries and states. So there are 2 systems. One is ARIPO. Under ARIPO, there are around, I think so presently around 18 to 19 member states who are party to this intergovernmental organization. And then we have African Organization of Intellectual Property. There is another system which again has around 17 member states. If you want to register a plant variety, Organization African Property Intellectual, this organization is party to UPOV, which is Uniform Protection of New Varieties convention, which Sara just mentioned. So once, if you register your plant variety over there, you can get registration over all 17 states which are member to OAPI, which is Organization African Property Intellectual. So you get this. Under ARIPO, presently they're working on a proposal to introduce something known as the Arusha Protocol for plant varieties, but this is still in process and it's still not functional. So this is one thing. Right now, if you have to protect your plant varieties, European SMEs, if they have to protect, they might have to look at individual countries' laws, or they go to OAPI, which is for one organization. Under ARIPO, there are member states who are party to UPOV, and some are not. So over here, you'll have to be more careful and look out which measures that you would want to take. Apart from that, there is also another organization, intergovernmental organization of Southern African states, and they are still presently working on a plant variety protection kind of protocol, but still, again, that is not functional. It will, what I hear is it should get operationalized soon. There are around 3 member states who have accredited to this, but still they need one more state to accredit, and then they ratify, they operationalize. So there is no one uniform system, but you can get your plant variety protection under UPOV. This would be the suggestion under the international agreement, and that per se would cover around 17 states under one intergovernmental organization, and a few other states which are consonants with ARIPO. Yeah.
So it's beginning to be a bit more complex, and I guess if we're talking about several countries, I will ask you some more questions about your geographical scope of India, but talking about several countries, I guess we can maybe turn to César. I don't know, we heard that it was centralized, uniform in Europe, also a bit the same for OIP in Africa. And how is it in Latin America? Because there are, how many countries? 18 countries covered by the helpdesk?
You can say so. It's we cover 18 plus. But yeah, well, as Girish, it's complicated. Well, talking about intellectual property and plant varieties anyway, so it's complicated. But you could say that there's a pretty decent level of harmonization, which is far from a centralized system, though. I mean, you got to take into account both international and national regulations. And in Latin America, the majority of the countries are members of the 78 version of the UPOF, what Sara mentioned, except the the Dominican Republic, Peru, and Costa Rica, which joined the 91 version. But then you got the local regulation. And here, general requirements, yes, they are almost identical, but you can find several additional requirements too. Like, for example, in Paraguay, there's sponsorship from an agricultural or forest engineer with an official national title registered in the National Registry, or having to provide information on the commercialization of the plant variety in Mexico or abroad, as well as the percentage share corresponding to each of the breeders in making use of the plant variety. So yes, a little bit complicated. I would say it's pretty decent, it's pretty okay, but it's not like patents, not like copyright, definitely.
So no harmonization. And I guess the audience would be not surprised at all if I share about Southeast Asia. Southeast Asia, it's completely not harmonized. Currently, we only have 3 countries, part of UPOF. Vietnam in 2006, they joined. Singapore, 2004, 2 years before. We have several countries which are in the process. Sorry, I said 3 countries, but well, there are 2 countries, Vietnam and Singapore. But currently in the process of accession, we have several countries, Malaysia, Brunei, Myanmar, the Philippines also, and then a third group of countries which are like in the early stage of discussion. Every country has one or several plant variety protection laws. The most, or the oldest one was in Thailand, 1999. And most recently, there was in 2017, Myanmar and Laos with specific plant variety protection laws. Very different duration of protection. It can go from 12 years, for example, in Thailand, to 20 years for, let's say, the majority of the countries of Southeast Asia, Indonesia, Philippines, Vietnam, Myanmar, Singapore. Then you will see another level of complexification, or like a big puzzle. It's that you have different coverage of protection for plant variety protection, like you have seeds and harvests in Malaysia, Indonesia, Philippines. You may have only the seeds protected and covered in Thailand. Propagation material, harvested material are the scope of coverage in Vietnam. And last but not least, you have a lot of exceptions when it comes to, for example, perennial plants, when it comes to vines and trees, when it also comes to the nationality even of plant breeders, like in Malaysia. So very complex topic, and you have to check it one country at a time. I have still many statistics about Southeast Asia, but let's progress a bit. And coming back to India, as it is now your real scope of geographical expertise, Girish, anything you want to share about plant variety in India?
Yes, thank you. Just reducing the complexity now, we just come to this one state, India, and things are more simpler. We just have one Plant Variety Protection Act and Farmers Breeders Protection Act. India is not party to UPOV, Uniform Protection of New Varieties, because India thought UPOV did not address concerns of farmers. So India has its own sui generis system. This is one thing. So you have a body, plant varieties body, where you go with a novel variety. And I think so the criteria have been laid down by Sara, which are uniform throughout. novelty, distinctiveness, uniformity, and resilience over time. So you can get your plant variety protected through that means. I wanted to mention another particular interesting case, which in India, which was in discussion recently, past 2 years, where there has been an intersection between patents and plant varieties. So Monsanto, we know, have this patent where they introduced a nucleotide sequence into a gene, into a cotton plant, and that has been patented. And now they had licensed this technology, and the licensor later on went to the court stating that this was not patentable. In India, we have this law stating that seeds or plant varieties per se cannot be patented. And Monsanto's argument was this was a nucleotide sequence, which is a microorganism, which was an artificially created microorganism, which can be patented. And the licensee, which was Zubimendi Seed Company, their argument was stating that nucleotide sequence, this is not a microorganism, but is a chemical composition. And because it becomes part of a seed, you insert it into a seed, and then next generation, the seed, the nucleotide the sequence was added to minimize bollworms. So it becomes part of a seed, and it is per se not patented under Indian patent law. This was Zubimendi's argument. But finally, the court went to the Supreme Court. The case went to the Supreme Court from the Delhi High Court. The Delhi High Court basically said that it cannot be patented on prima facie examination, and it went to the Supreme Court. But in Supreme Court, I think so, they missed the opportunity to come out with a clear decision, kind of differentiating the scope of patent system and the plant variety system. They basically said that they went back to the Delhi High Court to examine the patent in depth. And when all these things was happening, finally the parties kind of mediated, and they agreed to a licensing term, and the case was taken off. So now we don't have a perfect decision on the limits of the patent system and the Plant Variety Act per se, but this is an interesting debate which we will see further on in India. Yeah.
It's very interesting also when it reaches a higher level of courts, and it's almost super interesting when you're dealing about several IP rights. Are they compatible? What can they really protect? Also the fact that you cannot use a specific IP rights in a biased way to protect out of the scope that it should cover. We might see a bit of the same topic, some issues with, let's say, the interconnection between two other IP rights, the GIs, geographical indication, and trademark protection, which are also IP rights, which are quite relevant for our topic of today, the agri-food sector industry. Just very quick words on Southeast Asia. It might be the same or not. César will let us know just after. In Latin America, we're always doing some parallels because we are covering a large number of countries for the helpdesk. But yes, we have the principle of territoriality for IP. So 10 countries in Southeast Asia, which means 10 GI registration systems. You have several options when you're looking at national level in Southeast Asia, and it might be complicated to protect GI. You may either only have the GI registration system. This is the case, for example, in Cambodia, Indonesia, Laos, Thailand, Myanmar, only via trademark protection, which would be Brunei and the Philippines, or protection via a mixed system dealing with GI or trademarks. We'll see, maybe César will have some things here to say about collective trademarks, certification trademarks, because I think we have some similarities. But yes, maybe César, you want to jump right away on this? Is it almost the same? Are there some similarities between GIs and trademarks in Latin America?
Well, they have a joint field, you can say, because, well, as you mentioned, it happens in Latin America too, that Europeans' GIs are rarely recognized in these countries, to be honest. So even local companies can and even have registered some of them as trademarks, and that's legal. But besides that, trademarks and geographical indications have in common that both are a good mechanism to protect and highlight the added value and quality of geo-linked products. And I'm thinking of collective trademarks mostly. And they are amazing because you can get infinite lasting protection and have full control over your trademark, meaning who uses it and under which conditions. But if you take into account that they could also be the solution to too complex or almost impossible GIs application, then I don't know what you're waiting for to get yours. And that was the case, for example, for queso cordija, which is delicious, which after failing to register an appellation of origin, they ended up protecting their product through a collective trademark.
Okay. Now, I think it's maybe time to reach to the practical tips for SMEs, for companies, for people who are currently viewing us. And I would like to hear maybe from Matias, because we're all talking about like the positive aspects that it's possible to protect the IP, many assets, especially assets related to agri-food sector industry. But maybe there are some gray zones, some, let's say, shadow zones, no protection can be obtained or requested. Is it the case in China?
Yes, it is the case in China. Sadly, the seed law do not recognize the rights for export or imports. So all the rights that you may have over your plant variety are going to be for acts that you can do within mainland China. However, if you want to export, there's no going to be affected. There's not going to be any control. Also, one of the most relevant gray zones that we used to have in China was the harvest rights. But this was amended by the latest seed law that entered into force actually 10 days ago. So now we are looking forward to see how this is going to be implemented in practice. We still don't have experience on this because the law is extremely new. But we look forward to see, we congratulate, or we are very happy because of this change, and we look forward to see how this will be implemented.
So we'll have to keep an eye on the regulation and on practice.
Definitely.
Speaking of limits, do we have a bit of the same limits in India? Maybe with the plant varieties or biological resources, Girish? You're muted, Girish.
In India, we have this one particular mandate. If any European SME or anyone uses biological material which is derived from India, they need to get an authorization from National Biodiversity Board. They need to get this permission that they're using this material, and then they can apply for a patent, and they have to submit this with their patent application to the Indian Patent Office. So this is one thing. Apart from that, per se, nothing else. In the sense, with respect to GIs, agricultural GIs are available for even European GIs can be protected in India. Apart from that, nothing else. This one mandate, this authorization is needed for biological resources sourced from India.
Okay, thank you, Girish. I see César is like frowning. Any limitation, any exceptions when we're talking about biodiversity protection in Latin America? Because I know that there's a lot of biodiversity in this region.
They're really green. Well, genetic resources as found in nature can constitute the basis for new studies and development of plant varieties in Latin America because they cannot be protected as IP rights themselves. Okay, that's okay. But generally, you must gather an authorization from the government and attach a proof of it. And besides that, most Latin American countries, except Nicaragua, Paraguay, and Chile, have signed the Nagoya Protocol to the Convention of Biological Diversity, which aims to foster the fair and equitable share of benefits arising from the utilization of generic resources. And this in practical may constitute a barrier to development and protection by EU companies of plant varieties based on the research and development of these genetic resources in a Latin American country, meaning the endemic plants. Plus, many countries have established extra protection to protect the product derived or synthesized from the traditional knowledge of indigenous communities, which is this richness you were talking about, which in some cases cannot be used without their consent. This is the case of Ecuador, where regarding the country's biological and genetic heritage, the applicant must obtain an access permit to prevent damage to Ecuador's food sovereignty, food safety, and environmental safety. So full respect. And also in Brazil, they are really strict about it. And here, a declaration of access or non-access to traditional genetic heritage samples or associated traditional knowledge must be submitted. And if your company is intending to use such associated traditional knowledge, then you got to get the prior and informed consent from the native community providing such knowledge.
Okay. So now we heard some practical tips, also some limitations, some exceptions. I was wondering if we could have a bit more information on Africa, if there are any practical recommendations regarding agri-food and agri-tech industries. Maybe Girish, you have something to add? And you are again muted.
I don't know, any practical tips? I'm not sure. I don't know if the experts, if they want to join in, and if Nancy or they want to add something.
Maybe during the Q&A, we will ask again this question. Okay. So instead, maybe in here, if you will have the answer.
With respect to India, with respect to India?
Yes. For example, in India, if I want to invest, or not myself, but if a EU SME wants to invest in agri-tech, agri-food sector, what should they be aware of? Yeah.
So right now, what I'm seeing is I also had another session on agri-tech. India has been welcoming European SMEs with open arms with respect to technology. So there are particular states providing a lot of benefits with respect to patents or trying to encourage European SMEs to bring in their technology with respect to be it drone delivery or through other means of using water management technologies and stuff. So there is a huge push from the government itself to bring in new investment and new technologies to India. With respect to this, European SMEs have a lot of opportunity. Per se, everything need not be protected. What we have seen is patents is the preferred means of protecting IP when in agri-tech per se. But what we have seen is when European SMEs are going to India being niche players, I think so César mentioned initially about maintaining confidentiality. And if you're using algorithms and stuff which are not per se protected by patents, cannot be protected, you can protect these through NDAs, confidentiality agreements and non-disclosure agreements. So European SMEs, I would just suggest that European SMEs who would want to invest in India in water management and other agri-tech processes, if your product is basically based on software and using AI and all these new technologies, using trade secrets would be a relevant option to consider, and having very specific NDAs, non-disclosure agreements drafted would benefit you a long way, rather than seeking patent protection and then disclosing your invention. You can adopt the trade secret pathway. Though India does not have a per se legislation, contracts, and as I mentioned, NDAs and confidentiality agreements, they go a long way in protecting your invention.
Okay, it's perfect. You were talking about one of the last IP rights that we didn't talk about today. We talked about trademarks, GIs, also a bit of trade secrets and patents. So maybe it could be a chance for Matias to share about patents, maybe open license, anything you want to share about patents in China.
Yes, there is one characteristic of the Chinese patent law that do not exist in Europe that I would like to highlight, which is what you mentioned, the open license system. Basically, the patent office of the CNIPA, the China National Intellectual Property Administration, allows the patent holders to register any patent they have in order to be open for license. This means that you can simply set the rules, decide how much are going to be the fees, some conditions that you would like to settle, and any person that is interested in obtaining a license, they can just simply start paying the fee, and there's no negotiation process. The purpose of this is to facilitate the increased amount of licenses. And also it's a very good opportunity for foreigner companies because they will not have to struggle with the potential language barrier. There are some limits to this open license system. You cannot establish any exclusivity, but it also will grant you a very important benefit. If your patent receives many licenses, the fees, the annual fees that you pay for your patent will be reduced or even exempt. So for those companies that they see China purely as a potential market, this is a very good opportunity because it's a very direct way to start getting profits without the need of getting too much into details or investing too much in dealing with the language barrier.
Okay, thank you very much. So we just did like a quite big and quick overview of several IP rights, deep dive into plant variety thanks to Sara. I would just like to add some comments that yes, with the COVID-19 pandemic, we just saw that the agri-food industry is of systemic relevance because it's helped to safeguard the supplies of agricultural products and food for a specific population. It's vital for us. Food will remain and is the central need for all human societies, and we can highlight key global trends that we are seeing and that are shaping our world. The first is that we have a rising global population requiring access to safe and reliable sources of nutrition. The second is that we have an aging and more health-conscious kind of society in the global scope, and then that this society needs a different type of food of products with new functional characteristics, and IP is every time catching up with all these new trends. And we have also a global ecosystem under intense pressure, asking for an intense agri-food industry, and which also needs to significantly reduce the environmental impacts. These are all issues that are in the agri-food industry sectors. Right now, I would like to come back to a quiz that we saw at the very beginning to see if we have still the same answers. So you will have it on the screen. It's the exact same question as in the beginning. It's the closing poll. I repeat the question very quickly. Unlike other IP rights, plant variety protection is granted without any registration process. All new varieties will be automatically protected. True or false? I'll give you, let's say, 15 seconds because I think it's now quite obvious. Okay, I think we can close the poll. I'm not sure I remember, but I think yes. Okay, so now we see that everyone replied false. As far as I remember, not everyone was voting in the first part. So now we have, like, let's say, people that are more sure of themselves. I don't know if Sara, you wants to comment on this poll question or add something?
Well, as I mentioned, there's an application process, so it's not automatic as copyright is. So the protection goes through all the application process with us. Some practical tips, if I may, anyone can apply, personal or person or legal entities, and even from abroad, from outside the European Union. They just need a procedural representative, as we call it, in the European Union. So it can be an agent or anyone that represents a non-European business. And just for your information, SMEs, as it is the main audience of today, account for 90% of the applicants of the CPVR system. And they hold the 60% of the titles in force right now. Just a few interesting things.
I will share, because I know where these figures come from. I will share the link. It's a report from a joint report from EUIPO and the CPVO. Very recent, was published in April. I will share right now the link. It's very interesting if you are into the agri-food sector industry. A lot of other information. But right now we are reaching almost the end to this webinar. And I'm going to check if we have received any questions. But if you have any questions right now, you can ask them through the Q&A box. Okay. So far, we received one, but was already answered. Maybe in the meantime, because we are still together until, like, let's say 15 minutes, maybe I would like to invite our colleagues from Africa if they want to share anything on stage. I don't know if Nancy or Vere, you want to add. Hello, Nancy.
I don't know. Vere, would you like to go first? Okay, if my colleague Vere is not there, my name is Nancy. I'll just share briefly just a few commercial tips on plant variety protection in Africa. And I'm going to be talking about the Aripo region. I would say you'd need to just know three things. Number one, Africa is not the same. So know your Africa. Know the countries that you want to protect your plant varieties in. Number two, leverage on regional systems. In the Aripo region, we've got two formations for plant varieties. There's the Arusha Protocol, which has not yet come into force. It's waiting for, as I think Girish mentioned, a sufficient number of countries to join the protocol for it to be operationalized. We've got two member states right now, Rwanda and Sao Tome and Principe. But according to Article 40 of the Arusha Protocol, it will come into operation upon the ratification or accession of 4 members. So it is still going to happen, but it's good to watch it. Then the second regional formation that I can mention is the SADC Protocol on plant varieties. SADC is the Southern African Development Community. It's different from Aripo, but some member states are members of Aripo and ECOWAS. It is 9 member states, and it has a plant variety protocol. It has also not yet come into operation, but very soon it will come into operation. So it's good to leverage on these regional systems. And then the third takeaway that I can give is have layered protection. So in other words, just protect your plant varieties using other forms of intellectual property. And it's a point I think that Benoît has already made. So you can leverage the layering by protecting your rights using trademarks, patents, trade secrets, geographical indications. And then finally, what I can just mention is that the Aripo region, which currently has 22 member states, if we include Cape Verde, which is in the process of accession, and it will be a member of Aripo by the end of this year. And I've excluded observer states, which are Nigeria, Ethiopia, Angola, and quite a number of other states are all constantly, joining. Then it means you've got quite a huge pool of African states in which to look out for. So in terms of GIs, which you can use also to protect your plant variety protection in the layering system, ARIPO itself is creating a roadmap for GI protection, and it's quite big. And it's also augmenting this protection using the African Continental Free Trade Agreement, which has provision for an IP protocol. Right now, I think the African Continental Free Trade Agreement on IP protocols is at ground zero, but that doesn't mean to say that nothing is happening. The organization that I'm consulting for, AFRIPI, for instance, has seconded technical assistance to the African Continental Free Trade Agreement to capacitate, the creation of that IP protocol. That's all I can say for the ARIPO region. Thank you.
Thank you very much, Nancy. And the Africa Helpdesk remains active, and we already shared the website in which you can then go to each helpdesk and you have the contact details. Vere, if you want quickly to share some words on Africa too.
Thank you, Benoît. WAPI has 17 member states. The IP convention is Bangui Agreement. Bangui Agreement protected patent, utility model, trademark, GIs, industrial design, and plant varieties, new plant varieties. The protection of new plant varieties is under Annex 10 of Bangui Agreement, which into force in January 2006. This means that from 2006, WAPI received a PBR application. It is an uniform protection, one application for 17 member states, and one PBR for 17 member states. WAPI is, as an intergovernmental organization, is member of UPOV since June 2015, and that's mean WAPI receive international application, and the citizen of member states can apply to the international protection through WAPI. The member states is the member states are preparing themselves to join individually to UPOV convention. So I don't know if there is another, I can reply if there is a answer, I can a question, I can reply.
So far, thank you very much, Vere, for the information on UPOV and WAPI. So far, I don't see any questions. So either it means that everyone got all the information, or they are still processing the information, or maybe the question will come later by email, but we'll be happy also to reply. Maybe because we still have a couple of minutes, quick question for each one of you. Let's start maybe first with Sara. The main challenge, one main challenge you see between agri-food sector industry and IP?
The question is when?
It will be the same, sorry, it will be the same question for everyone. You have a bit less time to think, but yeah.
Well, I think that businesses need to strike a balance between what they want to reach, the markets, the assessment. There are several assessments to make, but I think that a good IP portfolio it's essential to strive in the market, because you have revenues that are coming in and that refeed your investments. And on top of that, IP titles, so irrespective of what they are a tool to attract investment as well. They are a value within a company. So they are valuable as IP titles. So we forget about tangible assets and we go for intangible assets as a mean to be attractive on the market. So I would say that it is difficult to choose, maybe difficult to choose for cost constraints and so forth, so on. But I would suggest to think about a strategy, an overall strategy, not only related to plant variety rights. Of course, I advocate for that, but any kind of IP right, I would say.
Thank you. Maybe César for Latin America. Do you have any recommendation?
So many countries, you wouldn't really have one single recommendation that would really make people's mind change and go for their plant varieties protection, trademark protection, even designs protection if they can. Well, it would be take that seriously. It really makes a sense to have your intellectual property rights registered, so you can really have exclusive rights, so you can really land there, have your licensing, your even franchise if you want to. Yeah. But you're going to really distribution agreements really secured. If you don't do that and you want to say, oh, I'm just sending some crop in, it doesn't make a sense to do that, or it's too expensive. You know what's expensive? Losing all the money you'll have to face in trials because you didn't protect properly, or seeing how much money you lost because someone else did it right and you are out of the run. This is really what costs a lot.
Would it be the same in China? Registering is the most important thing. Register as soon as you can.
It is exactly like this. If you have no registration done in China, then you have nothing to do in China. Without an IP certificate, you won't be able to enforce absolutely anything. And you have to be very careful when coming to China, because China is divided into 4 different jurisdictions. You have mainland China, Hong Kong, Macau, and Taiwan. And each one of them is independent. And if you want to be fully protected, you have to be registered in the 4 jurisdictions.
Okay, thank you. Any last word, Girish, before I just wrap up?
Nothing much. Thank you, Benoît. Just reiterating what Nancy and Sara said, you have to leverage, have a layered protection and register all your rights and basically strategize. Layered protection is important, but as we saw, there are some delimitations between patent and plant varieties, and also coming to GIs and trademarks. So strategizing, because there is a cost involved, would be the main thing that I would say. Strategize and then venture into any of these markets. Thank you.
I would say education, yes, learn, and well, follow the helpdesk because we have a newsletter. We have also a lot of publications. There will be other very interesting webinars and trainings. So just be updated. And here, just to show you 2 interesting guides that we have. One is about PCT, Patent Cooperation Treaty, on behalf of International IP SME Helpdesk, and the other on the International Trademark System. It's in English, it's quite easy to understand. Each one of us, the experts, are also super easy to reach by email via the contact info on the website. So now it's the end of this webinar. Thank you very much, Sara. Thank you for the CPVO for joining us today and sharing about the plant variety protection system in EU. Thank you very much to the team Southeast Asia, Nora and Shang behind us for the logistics. Thank you to César, Matias, Girish, Vere, and Nancy for joining us today and sharing about the particularities in each of a region, and each person is part of a helpdesk, as you may have understood. Thank you very much for attending the live session, and we hope that you enjoyed. And if you still have questions, well, you know where you can find us. We will answer by email. Thank you very much, and well, have a nice afternoon or a nice day ahead.
Thank you. Bye-bye.
Thank you very much.
Bye-bye, everyone.
Bye.
Bye-bye.